Welcome to the other side of Lucy Letby. In episode 53, we're going to continue with this Court of Appeal ruling that denied Lucy Letby the right to appeal. It was heartening to hear Sir David Davies, Tory MP, speaking in the House of Commons on January the 8th, reiterating once again that there is no hard evidence, and I would say no evidence at all, against Lucy Letby. And that much of the evidence that was presented was a doctor's gut feeling. And I presume there he's referring to Evans. And as far as I'm concerned, it's not a gut feeling, it's a confabulation. And he said that he'd been contacted by employees of the Countess of Chester Hospital where Letby worked in confidence, and other medical and academic experts. And again, we have to wonder where all these people were, like me, when the trial was actually taking place. And we were ill-informed is basically where we were. And he makes the same point that I make. I can't understand it. So David told the Commons, there is case injustice, in my view, for a retrial. But there is a problem. One of the problems we face is that much of the evidence was available at the time. What I have described is an expert analysis of the case notes, which were there at the time, but it was simply not presented to the jury. This means the Court of Appeal can dismiss it, basically saying the defence should have presented it at the initial trial. It is in essence saying, if your defence team weren't good enough to present the case, hard luck, you stay banged up for life. Now that may be judicially convenient, but it's not justice. But it's also worse than that. What the jury did here didn't happen, or it certainly didn't happen for the reasons these people, the experts in this trial, said it happened. And that's because largely what they said happened is actually physiologically impossible, as I pointed out on many of these podcasts. So it's good to see that the fight goes on, and I think it's just going to keep getting worse. More and more information about this appalling situation will continue to come to light, as it has through the Thirlwell inquiry and as it will through the Criminal Cases Review Commission. The judiciary would be wise to get on with it now, but they won't. And we'll return to this judgment here, paragraph 88, to see just what kind of crap we're dealing with from someone who says they're an expert. Paragraph 88, Dr. Bowen denied when it was put to her that her role in the prosecution was to rubber stamp the opinion of Dr. Evans. She denied that she was supporting his views or backing him up so far as she was able to do so. She said that she was coming to her own conclusions and that if her views were in alignment with Dr. Evans, then that was because she agreed with him. And I would agree with her. I think it's wrong to blame Dr. Evans for all of the nonsense the jury was told at the trial, because Dr. Bowen was very good on her own at inventing stories and depicting babies who are obviously sick as stable. We must never let her forget what she said about the father of baby D. This woman accused him, with great respect, of choking his own child. And even Barry, who was in the court with her, said in an email properly at the time that the baby had died of sepsis because of the negligent treatment of her premature rupture of membranes. And why could Dr. Bowen not bring herself to say this? It's so obvious. And paragraph 88 carries on. She was asked once again to identify the clinical features of her embolus. She said that she had a very limited clinical experience of the condition, which was rare. So she was relying upon the literature in which the condition presented as a full unexpected collapse, and the person dies. Or it can present with a collapse where, after resuscitation, the person recovers. That is Dr. Bowen's definition of an air embolism, in a nutshell. And these Court of Appeal judges think that's okay. So it isn't as if Mr. Myers for the defence did not ask these experts to put something into evidence as a fact. It is instead the case that these experts chose to put crap like this into evidence as fact. But what Dr. Bowen has just described there is every cause of collapse in a human being, which means that her understanding of the pathogenesis of the pathophysiology of our embolism is very limited indeed. And she says she's relying upon the literature. No one would put that into the literature, that every unexpected collapse from which a person either lives or dies is caused by the presence of an air embolism. Yet that's what she's just said. And then she goes on to describe this circumstance, a collapse, as proof that it's an air embolism. The Bible is true because the Bible says so. He says there may be a drop in blood pressure. Well, if there's no drop in blood pressure, then it's not a full collapse. There may be a drop in heart rate. There may be skin changes. The clinical presentation is wide and varied. So that is my theory on how our embolism presents. So we have every collapse that has ever happened in a human being. A person collapses because their blood pressure falls. Most of us call it fainting. When a person faints, they may go very pale, and as they recover their blood pressure in the supine position, lying down, they may develop skin changes as the circulation restores itself to the peripheries. That is the description of a faint, which is no different than Dr. Bowen's description of her theory of how our embolisms present. So because something is wide and varied in its clinical presentation, which is just about every disease I've ever come across, no two people get it the same way, whether it's pneumonia or a heart attack. Let's have a quick look at what the literature does say about the presentation of our embolism in preterm neonates. And trigger warning, it's 1,000 miles away from what Dr. Bowen says the theory of presentation of our embolism is in preterm babies. So from the American Journal of Peri-Neonatology, we have Kui Choi and Shu K. Lee, work supported by the Canadian Institutes of Health Research, so not Big Tam on Facebook. And it's an abstract which aims to bring up to date the presentation of all of the case reports of vascular air embolism in neonates. And they managed to find 117. The majority, 90%, were preterm, male, and on mechanical ventilation. So that excludes nearly every other cause of collapse as defined by Dr. Bowen. So fainting isn't a presentation of our embolism, even though it's a full collapse with a drop in blood pressure and a change in skin coloration. 3/4 of the presentations in Shu Lee's new paper are preterm babies. Well, that excludes all the other causes of collapses in adults then, doesn't it? Clinical presentation was sudden acute clinical deterioration, sometimes accompanied by crying, cardiac rhythm abnormalities, skin discoloration, and a decrease in end-tidal carbon dioxide concentration. But the problem with this is that that is a description of every neonatal collapse. So whether it's respiratory distress, cardiovascular instability, tachycardia, low blood pressure, poor pulses, signs of shock, neurological changes, seizures, temperature instability, fever or hypothermia, feeding difficulties, vomiting, abdominal distension, skin changes. And those skin changes are what we call livedo reticularis and are associated with the presence of shock from any cause. And preterm neonates would be particularly susceptible to this type of skin change because the methods of regulating the skin temperature and flow of blood to the skin is not mature yet. So the skin discoloration starts with low flow of blood to the skin. which will cause the appearance of cyanosis. This is followed by vasospasm, that's contraction of the muscles within the walls of blood vessels in the peripheries. And that's going to give the impression that the skin discoloration is moving, but nothing is moving except the flow of blood locally. As the shock worsens, the flow of blood will change with that. And if there's a buildup of catecholamines, that's adrenaline, in a localized area on the skin, that's going to cause vasospasm, which is going to push blood elsewhere. Now, don't forget, all of these babies were receiving artificial resuscitation, most of the time with 100% oxygen. So even if the baby isn't putting out perfused blood, that's very red blood itself, the resuscitation is. And so these areas of white and blue and red are going to fluctuate depending on whether the circulation is passive, that is when they're not compressing, or active, that is when they are compressing on the chest. You fire 100% oxygen into the baby's lungs, fill it up, and then do a compression. You're going to send a lot of very red blood around the circulation of a tiny baby, and that's going to show up. But it's not going to stay there. All of the oxygen that you've just supplied by that compression will be soaked up and used by every organ it passes through. The oxygen gets depleted, the blood appears to turn blue, and you start the cycle all over again. And that's how you produce a fluctuating, flitting red rash against a generally cyanosed or pale background. It is just that simple, and it's got nothing to do with our embolism. In paragraphs 89 through to 97, we get another review of Baby O, and in paragraph 90, we get our first major mistake, factual mistake. Paragraph 90 says Baby O was breathing normally. Baby O was not breathing normally. Baby O was breathing under excessive pressure. And then they go on to say that Dr. Cook undertook an abdominal examination of Baby O, which revealed that the abdomen was full but not distended and was soft and not tender. This examination effectively established that no liver damage was present at the time of the examination. So here again we have the appeal court judges making statements that are not factually correct. A physical examination can never rule out the presence of a subcapsular hematoma or a liver hemorrhage in a preterm baby. In fact, it's so difficult to diagnose that 75% of them in one review were diagnosed post-mortem, not ante-mortem. So again, the purpose of paragraph 90 is factually not correct. In paragraph 91, they say Baby O collapsed shortly after 1439. A nurse responded to the alarm call and found the applicant alone with him at that time. That's Lucy Letby, obviously. Dr. V, a consultant, attended. Baby O was moved into nursery room 1. He had mild metabolic acidosis caused by, the prosecution allege, the accumulation of blood in the abdomen secondary to liver injury. During the intubation, Dr. Breary noticed an unusual small rash on Baby O's chest. Here we go back to the skin discoloration, coat of many colours, omni symptom, the ultimate CMA. And Breary said that this discoloration looked like something normally associated with meningitis. That's petechiae, or purpura, or ecchymosis, depending on how big the lesion is. And it says he was concerned because at the time the baby appeared to be well perfused, which is at odds with a collapse caused by a liver injury that was the equivalent of a road traffic accident. If Letby had caused that liver injury, the baby would have bled out very quickly. And at no time after that injury would Baby O have been well perfused. So by stating, Dr. Breary stating that Baby O was well perfused. He's also stating that Lucy Letby did not cause a liver injury equivalent to a car crash. And the paragraph continues, he was successfully resuscitated at 15:49. Baby O collapsed again. He suffered a further collapse at 16:15, from which he could not be resuscitated. And that, we know, was when the actual liver injury occurred, not at the hand of Lucy Letby, but at the hand of Dr. Breary, who made a very unwise decision to perforate the abdomen blindly on the right-hand side, likely not knowing that the liver was in the path of whatever needle he used or cannula he used to vent the distension of the baby's stomach, similar as some people may know of what you do when a sheep has bloat. Moving on, paragraph 92, Baby O's father, who was present during the afternoon, said that Baby O's stomach was swollen like E.T. And then there was a point where you could see all his veins. They were bright blue, all of them, and they were going different colours, and his actual body looked like he had really, really bad prickly heat. And that got worse, and then it went down again. It was literally like you could see something oozing through his veins. What a horrible experience for that father. But the only thing that you can see oozing through the veins is blood. The blood is deoxygenated, and even though it is red, it's a crimson dark red, it appears to be blue. It's worth noting that the term blue-blooded in relation to the landed gentry came about because people who didn't work on the land were very pale. And being very pale, it meant that their blood was more visibly blue on their skin, which the father is describing here for his poor child. And it's due to failure of circulation and nothing to do with our embolism. And the patch of discoloration looking like meningitis that Dr. Breary noted turned out not to be so, and forced Dowie Evans to change his mind about his diagnosis, because the discoloration lasted for about 45 minutes. So it no longer fitted Dr. Bowen's embolism theory. Paragraph 93, at post-mortem, free, unclotted blood was found in Baby O's abdomen. There was damage in multiple locations on and in the liver, which had then bled into the peritoneal cavity. And that was caused by Dr. Breary, and could not have been caused by Lucy Letby, because if Letby had caused the injury at the time she was said to have caused the injury, the blood would not be unclotted. It is unclotted because it happened at the time of death, and therefore it can be reasonably assumed that the bleeding from the liver was the cause of death. The hyperventilation was the cause of the distension, which led to the insane attempt, in my opinion, to aspirate air from the abdomen using a cannula on the right-hand side, which in turn led to damage to the liver, hemoperitoneum, and death. Nothing to do with Lucy Letby. And paragraph 94, we have Dr. Marnarides showing up again. The reviewing pathologist said that taking the location, extent, and distribution of the liver injuries into account, they could not have been caused by CPR. The possibility of CPR being the mechanism of injury was, at its highest, a theoretical possibility. He said that this type of liver injury was only seen in serious accidents, road traffic accidents, bicycling, trampoline accidents, and that he had never seen it in the context of CPR. It was the prosecution case that the applicant was responsible for Baby O's death by inflicting those liver injuries, and additionally by instilling air into the venous system, causing an air embolism. Dr. Marnarini said that in the neonatal unit, the staff are trained how to do CPR. One may see bruising to the liver, but it would be very small areas of bruising distributed over the surface of the liver. The liver is not the anatomical site where the CPR is applied. He concluded that the cause of death was best given as inflicted traumatic injury to the liver, correct? Profound gastric and intestinal distension following acute excessive injection of air via the nasogastric tube, correct, caused by the ventilator, not Letby, and air embolism due to administration of air into a venous line. Well, if there was any air there, it more than likely got there when Dr. Beery took the very extraordinary and unconventional decision to stick a needle into the baby, opening the entire abdominal cavity to the possibility of air entrainment. Paragraph 95, with the good Professor Arthur's returning, and he refers to radiographs from the postmortem examination which showed gas in the heart, one of the great vessels. Again, this is postmortem. Why did he not refer to the x-rays that were taken during the resuscitation? This was an unusual finding, said Professor Arthurs, which is sometimes found in cases of necrotizing enterocolitis, which he did not have here, or after severe trauma in older children after resuscitation. An alternative explanation for the presence of gas in baby O's case was air embolism. And you can add a new one to your 400 case review, Professor Arthurs, sticking a needle into a baby on the right-hand side. While the resuscitation continued and the ventilator turned the cannula into a food processor, and Dr. Marnarini's can add a food processor to a pot thrown from a helicopter to his little collection of causes of death. Paragraph 96, Dr. Evans weighs in. He had been provided with information concerning baby O piecemeal. I wonder why that was. On the basis of the whole picture, however, he concluded that the cause of the sudden collapse was likely to be the result of air embolism, together with bleeding within the liver and into the peritoneal cavity. So, in Dowy's words, Lucy Letby kicked the baby at the same time as putting air into the vein. This conclusion was in part based on the description of a rash by Dr. Beery, which had disappeared after a short time. This was the rash that forced Dowie Evans to change his mind. And it seems unbelievable to me that the two neonatologists that have since reviewed the case notes of baby O, meaning they don't have any other information that Dowie Evans didn't have, or that all these other experts didn't have, but came to an entirely different conclusion. And if you're looking for something that is odd and unusual, as these consultants are wont to do, you'll never find anything more odd or confusing or unusual or absolutely stupid as putting a needle into a preterm baby on the right-hand side of the abdomen with no guidance and an x-ray apparently showing you that the pressure was so great that the liver had been displaced downwards into the pelvis. Putting a needle anywhere in the right-hand side means you're almost guaranteed a bullseye on the liver. And it was, in my opinion, a crazy thing to do. And then in paragraph 97, we get Dr. Bowen weighing in with the wisdom of Solomon. Dr. Bowen said that the abdominal distension and x-ray findings were due to excessive air having been administered via the nasogastric tube. No proof needed. She did not accept that it was plausible that CPR had caused the damage to the liver. She agreed that the collapse at 1440 was due to air embolism. That on the basis of a patchy skin discoloration, which Dr. Beery later changed the description of. He said that in reaching a conclusion about air embolism, she was relying on a constellation of factors. Here we are back to our astronomical comparator. No one can name a single point of evidence that convicts Letby, but they can and do point to a constellation of them. She noted Dr. Arthur's view that there was air in the great vessels. Post-mortem, ergo useless. Why do none of them know this? She thought that the rash on the chest wall was due to air embolism. No, it wasn't. She accepted that on its own, the 1 to 2 centimetre rash did not establish air embolism, which is just a contradiction. She said that the rash was indicative of air embolism, but she said that it can't be indicative of air embolism. And she goes on to tell us what we already know because I've told you 1,000 times. She said, I think what's come out across the whole of this trial is the huge variation in the type of skin changes seen by parents, practitioners, nurse practitioners, doctors of these children, and certainly the medical and nursing personnel are very clear that they have not seen changes like this before or since, but that the changes appeared quite graphic. And so, although there is not one single thing that you can say is definitely pathognomic of air embolism, that is a bit like saying that all chickenpox rashes are not different. They are, but you still have chickenpox regardless of whether you have 2 spots or 500. The rash varies, and this is the logic that we're stuck with, and we really are stuck with it. And until people can see just how absolutely, utterly batshit crazy this stuff is, we're not going to make any progress. It doesn't matter what rash or discoloration you're looking at. They are all perceptions which never appear the same in any two people. But all of the discolorations and the morphology, that is the shape, histology, that is the microscopic appearance on biopsy, and pathology, that is the disease that you might associate with a skin discoloration or rash, are all explainable. There are no mysterious rashes. What we have, if we have a constellation of rashes, we have a constellation of causes. But in this case, we don't have a constellation of causes. Every skin discoloration, every rash, every bump and blister is an air embolism to these people, because when all you have is a hammer, everything looks like a nail. And the story of Lucy Letby as a killer requires the use of a hammer. But you think about it, you get 20 people describing 20 different skin discolorations, and with their description comes the opinion that they'd never seen that particular rash before. So 20 people describing a completely different graphic rash always leads to the same conclusion, that what they were observing were the consequences of air embolism. That also applies to 40 people, 60 people, 80 people, or 100 people. It's a fail-safe method of diagnosing air embolism, even though you say that there is no specific rash for air embolism, which is the beauty of air embolism. If you were trying to frame someone, think about it. Instead of saying, we found this weapon on this man, it was the murder weapon. We matched it to a bullet in the victim. The victim's DNA was also found in the blood that was splattered all over the perpetrator's clothes, skin, and car. Both the victim and the perpetrator were both seen arguing 5 minutes before a gunshot was heard by 20 witnesses. Each of the witnesses described the gunshot as something they hadn't heard before, and there were 20 different descriptions of the sound, from boomy boom boom to clappy clap clap through to thunderclap, very graphic thunderclap, barely audible thunderclap, but graphic nonetheless. Now, in the course of the trial that comes in this situation, it turns out that the murder weapon wasn't the murder weapon. that the DNA wasn't the DNA, that it was someone who looked like the perpetrator who was having a discussion with this victim before he was killed. So now all we're left with is the clappy clappy boom booms, a constellation of graphic and unusual sounds that people associate with a gunshot, even though they've never heard a gunshot before. The question is the evidence more reliable now because we have 20 different descriptions of it? And remember, no one's heard a gunshot before anyway. Or would the evidence be more reliable if we had a single description? Remember that 100% of nothing squared is still nothing. But we all know that this is much worse than this silly scenario that I've just given you there. Vital evidence was withheld from the Letby jury. There can be no doubt about that. And so far, up to paragraph 97, all we've heard from these appeal court judges is a repetition of the same nonsense that a jury heard. And we can't put any of the facts that we do know, such as stabbing a baby in the liver with a cannula, into evidence, not because it didn't happen, but because no one mentioned it at the time of the trial. So instead of very factual, detailed, and vital evidence like this that tells you exactly why there was such massive damage to the liver of baby O and unclotted blood in the peritoneum, we have to stick with the clappy clappy boom booms rather than the facts, because that's what the British call justice, not the British people, of whom I know many and have great respect. In fact, oddly enough, I regard England as one of the finest countries on earth. It just has a crappy legal system. So we move on. Ground one now we get to the application to exclude the evidence of Dr. Evans. Paragraph 98. We have referred already to the role that Dr. Evans played as an expert both in the investigation, which gave rise to the applicant's prosecution, and at the trial. And as we say in Ireland, there's no show without punch. Paragraph 99. The defence made its written application to exclude his evidence on the 5th of January 2023. The application was heard on the 9th of January 2023. By that stage, as we have said, Dr. Evans has given expert evidence in respect of the incidents giving rise to counts 1 through to 9, which related to 7 of the babies, materially for present purposes, baby A, B, C, D, E, and F. The defence invited the judge to exclude the evidence Dr. Evans had already given by directing the jury in due course to disregard it on the grounds that it had failed to meet the standard of admissibility for expert evidence. It was submitted that Dr. Evans' failure, as it was said to be, to comply with the requirements for expert evidence in Rule 19 of the Criminal Procedures Rule 2020 and Criminal Practice Direction 19A, now replaced by the similar provision of paragraph 7 of the Criminal Practice Direction 2023, raised questions of admissibility and not weight. Paragraph 100. The defence also submitted Dr. Evans' evidence had had such an adverse effect upon the fairness of the proceedings that any further evidence from him should be excluded, pursuant to Section 78 of the Police and Criminal Evidence Act 1998, PACE. The defence relied upon Jackson, LJ, decision on the paper, see paragraph 35 above, as supportive of the application to exclude Dr. Evans' evidence, but in the alternative applied for permission to adduce the decision as relevant to the weight to be attached to Dr. Evans' evidence and or his bad character under Section 100 of the Criminal Justice Act 2003. So we obviously have a load of rules here that are parts of Acts of Parliament. Now, if you write a rule that's intended to make clear who can and cannot give evidence in a criminal trial. The rules should be written so clearly that there would never be a need to question whether or not a person already participating in a trial as a witness met the standard of that rule. But clearly that's not the case. In paragraph 101, in his decision, Jackson L.J. said, "Finally, and of greatest concern, Dr. Evans makes no effort to provide a balanced opinion. He either knows what his professional colleagues have concluded and disregards it, or he has not taken steps to inform himself of their views. Either approach amounts to a breach of proper professional conduct. No attempt has been made to engage with the full range of medical information or the powerful contradictory indicators. Instead, the report has the hallmarks of an exercise working out an explanation that exculpates the applicant. It ends with tendacious and partisan expressions of opinion that are outside Dr. Evans' professional competence and have no place in a reputable expert report." In paragraph 102, the defence said there were many different issues relating to credibility which were fundamental to the character of Dr. Evans' evidence. Amongst the matters raised were Dr. Evans' involvement in the investigation into events at the hospital, which was said to be to an unusual extent, with the consequence that he had acted as an investigator rather than an independent expert. And various examples were given from his evidence in cross-examination to support the submission both that he had constructive theories to support the allegations of the indictment and had given evidence in a manner that was improperly subjective, emotive, dogmatic and biased. And why don't you chuck in fantastical at the same time? He invented the entire Araminism story, the killing babies by injecting air into their stomach story, which he has since withdrawn, to say that it's not a cause of death, but is a cause of destabilization. But sadly for Dowie, if it is a cause of destabilization in preterm babies, it is also a cause of death. Disease processes do not self-limit in extremis. In other words, if you have a condition, a set of physical circumstances that can destabilize the body, it can lead to death. But since Evans never has to explain the physiology or the workings of his theories, he just chops and changes them all the time. We get to paragraph 103, the overarching position of the prosecution was that the various criticisms of Dr. Evans' evidence were, with the odd exception, not well founded, but in any event went to his credibility and to weight to be attached to that evidence by the jury in due course, rather than admissibility. Further, it was said, were the evidence of Dr. Evans to be excluded, the appropriate course would be to discharge the jury, rather than carry on with the trial. The prosecution did not oppose the admission of Jackson L.J.'s decision, but again submitted it was material to the weight to be attached to Dr. Evans' evidence, but not to its admissibility overall. So here we get into the typical legal argument for the sake of it. Prosecution allows Justice Jackson's opinion into the court because it knows it has no option. Justice Jackson, as I understand, actually wrote to the court. And now the prosecution are going to split hairs on whether a man, Dr. Evans, whose credibility is torn to shreds by Justice Jackson, who literally accuses him of working out an explanation, which is exactly what he's doing here. Everything this man says is fantasy. He doesn't cite articles or point to any source of his knowledge, because there is no source of his knowledge. And rather than accept that about this man, the lawyers are going to let the opinion of Justice Jackson into the evidence and then argue that his lies are not big enough to mandate their removal from the facts, but rather the lies should be assessed by the jury and not Justice Jackson to inform them whether or not Evans is a reliable, responsible witness. Which begs the question, why do we have the rules in the first place? If we are going to leave the decision to the jury, then we don't need rules to prevent people like Evans coming before a jury. The jury is obviously omnipotent, all-knowing. And then the prosecution seems to imply that the defense asked for the wrong thing, that they should have asked for the jury to be dismissed rather than for Evans to be dismissed. And in paragraph 104, the prosecution made some general points to rebut the allegation of bias and unreliability, including that almost every opinion given by Dr. Evans was corroborated by another expert. And that would just happen to be experts that Dr. Evans picked as part of his role when advising the Cheshire Police. An enormous conflict of interest when it comes to the administration of justice. In addition, it was pointed out that Dr. Evans was the person who had identified that 2 of the babies had been poisoned by insulin, baby F and baby L. This was a matter that had eluded the treating medics and went to prove that someone was committing serious offences against babies on the unit. And it was particularly important independent evidence bolstering Dr. Evans' credibility and reliability. Except it wasn't, because in the case of baby F, the blood sample was contaminated, and there is no doubt about that, because we've seen a report from the Farewell Inquiry that shows that the blood glucose measured in baby F's blood was 999 millimoles per litre, and that a senior technician verified that. 999 millimoles per litre is incompatible with life, which means that, to me anyway, the sample was contaminated with glucose, or the machine read it wrong. But it doesn't really matter. Any doctor who received that test from a laboratory couldn't use it to make a medical decision, and therefore it should not have been allowed into a murder trial as evidence of a crime. In the case of baby L, we have the erroneous opinion of Dr. Evans and Dr. Hindmarsh that the insulin C-peptide ratio should always be a fraction. In other words, that the C-peptide always has to be higher than the insulin measurement, which is not what experience shows when we're talking about preterm babies. And this is the work that Helen Shannon and Jeff Chase are currently finishing off, and which should open up this entire insulin C-peptide debate from the rigid Professor Hindmarsh adult interpretation to a more realistic interpretation with regards to preterm babies that have entirely different glucose profiles. Finishing off paragraph 104, further, when Dr. Evans reached his conclusions, he did so without knowing about other circumstantial evidence relied upon by the prosecution in establishing guilt, including the applicant's Facebook searches, the shift pattern evidence, and the confession in the note recovered from the applicant's home on July the 3rd, 2018. Well, we've said before, the Facebook searches account for 21 people out of the thousands of searches, and there is no evidence that they were anything other than a peculiar trait of Lucy Letby, which is not criminal. The confession note was not a confession note, and the shift pattern is a statistical abomination, a fake, like nearly all the evidence in the Letby trial. And we go to paragraph 105. In relation to the specific examples from Dr. Evans' evidence upon which the defence relied, Mr. Johnson accepted there had been a particular error into which Dr. Evans was led by prosecuting counsel in re-examination. This was through fatigue and inadvertence on the part of counsel and the witness in relation to the one issue relating to baby B, and he acknowledged that the defence relied on the cumulative effect of the examples given. But he said it was important to look at the substance of each of the specific complaints rather than the adjectives used by the defence to describe Dr. Evans' evidence generally. This the prosecution was able to do, and it individually addressed the complaints and answered each of them. As to Dr. Evans' involvement in the investigation and prosecution, there was nothing in the material itself that compromised his objectivity or capacity to give an independent view. And given the context, that is, that he had been asked to consider the cases referred to him by the police, his input into the structure of the investigation and the way in which it should be carried out was appropriate. And here we have another train of untruths that Dowie Evans has since led bare after the trial because he can't keep his mouth shut. The police did not invite him to look at cases. He invited himself. He also told Raj Persaud that the police were very happy with what he was giving them, and this in return made Dr. Evans feel happy. It was not Dr. Evans' job to make the police feel happy. For me, paragraph 105 is a rewriting of history, and is clearly without any factual basis. The Dear Nick email seems to have been forgotten. The "oh my God, I knew within 10 minutes that somebody had killed this baby" by inflicting trauma externally to the liver, a conclusion that we know is not now true. Baby O was one of the first cases that the police fired Evans' way. But strangely enough, it's reported by the judges in this ruling that he received the information about Baby O in a piecemeal fashion. Why did he get the information in a piecemeal fashion in the first case? Why does any expert get information in a piecemeal fashion in any case? It seems to me that the role of Evans in this trial was unique in British history. I have said time and time again, Operation Hummingbird or the Golden Thread was Dowie Evans. The cops admitted that they knew nothing about medicine and were incapable of making decisions as to whether any harm had actually happened to the babies. They relied 100% on Evans to give them guidance as to whether these babies had been harmed or not. And we now know that they also received guidance from one of the consultants that actually injured Baby O, which is the very definition of conflict of interest. And so there is nothing about this trial that looks kosher. It's all a bit iffy and has, strangely enough, fallen apart quite spectacularly and will continue to do so. So we're going to end this episode here, and in the next episode we'll get to paragraph 106, which is ground one, the judge's ruling on Dr. Evans' evidence. So this is going to be a look at what way Justice Goss was thinking when he was properly asked to remove this little man from a murder trial. So I will find it interesting, and I hope you do too. See you in the next episode. Bye.